Cheryl Stephens. She's Dr. Foucault. Sorry, my bad. I saw cut up. Thanks so much, Daniel, for. I want to introduce her on stage. We are gonna talk about justice. Thanks so much for all that are being here. It's been like probably 8 hours now, and we are live, and we are gonna keep going live till the end of the night. So for now, okay. Lindsay, help me out here. Send me like a set.
No worries, Augustine. He's worn right out, as you can tell. So I wanted to just one last time. I thank you very much to Farah. That was a great presentation, and I'm like my brain is completely overwhelmed. I think that's what happened to Augustine as well. And now we're welcoming. It's okay. We're welcoming Cheryl Stevens to the stage, as it were. Cheryl's doing a presentation on social justice, so, cutting edge legal innovations that are actually going to make a big difference in terms of access to justice. So I'm really quite excited about it. We have about a minute sort of to set up while we're waiting for others to join us. Augustine, thank you very much for all
What I do know now is that someone of you two needs to stop recording, wait for like 30 seconds, and start recording again.
I did it.
And there's like so many people joining in, and so many names, and so many hours live. And I'm going to Clubhouse. That's sorry that I'm just like drowning here, but we feel tired, and there's probably the half of the day to go through. So, well, bear with us, and thanks so much for being here, and thanks, Lindsay, and we continue the best we can.
Thanks for your efforts, Augustine. Go and look after everybody in Clubhouse now, okay? All right. And Cheryl?
Yes.
Oh, great to have you here. Oh, and your slides are up. This is marvelous. See you and we can hear you. It's all good news.
Okay. I wasn't successful in putting my speakers pinned. I don't know why. So let me know when we're ready to go.
That looks great. Can you go into presentation mode or? You don't have to if it's not comfortable for you.
No, I just.
It's devilish, isn't it?
Yeah. I'm going to stop the share for a minute so I can maybe find the adjustments. And
all right, that sounds great. While you do that, I'm going to mention a couple of things to people who've joined us who might not know. We've been running this event since 7 a.m. this morning. We're going till 8 a.m. tomorrow morning, or some of us are. I don't think I can do it. We've had a lot of really interesting sessions today. All of them we have recorded, so you will be able to catch them later if you missed them. We have seen a lot of new faces. We've been encouraging people to, if they are not members of the guild, to join the guild. We have just recently, we've hit over 1,000 members. Guild membership is open to everybody. We have a number of fascinating presentations coming up, including, and I always like to point this one out because Augustine and I are both desperately waiting it, a cocktail hour at 8 o'clock. Swan cocktail hour, which will feature a special guild cocktail and all kinds of great conversation, I believe, followed by an online magician. So, sucker that I am, I love a magician, but a virtual magician, that's neat stuff too. So don't forget to keep looking at the agenda to see what's on. There are some sessions going on in Clubhouse at the same time for those of you who are keen on Clubhouse and want to bounce around. And I will also refer you back to the fact that we have had a a virtual journal that we've been building all day that everybody who attends these sessions is invited to join in and add to. And I'll throw some of these. I see somebody's doing it for me. I think probably Rob. We'll throw some of these URLs into the chat for you. Are you feeling good, Cheryl?
Yes, yes, yes.
Excellent.
It's a sunny day where I am. Okay, so here we have, I'm hoping you can see that screen with the list of our speakers.
No,
and
we're not seeing your screen yet.
Oh,
Nuts.
All right.
I'll say it for you. Nuts.
Then we go to...
I'm calling the magician.
Yeah, just give me a minute.
That's no problem, Cheryl. We're good. Thanks very much.
Okay.
Oh, yeah.
Now we've got it.
If you go to display settings, you can probably set that to full screen.
Yeah. All right. Okay. I don't hear anybody. Have we got it?
One down. The next selection will duplicate your slideshow on both your screens. Or you could just present like that. That's fine.
Yeah, thanks. Okay, so this is about doing justice. The phrase that's popular in the legal circles is access to justice. But I like to think we're going to actually do justice and move along a stage. So I wanted to find the problem, which is that legalese and legal procedures are archaic and they don't relate to anybody's modern experience. So people feel overwhelmed and intimidated and frustrated and stressed out when they encounter the legal system. And the law field talks about having legal literacy as an extra requirement in order to engage with the legal system, which law literacy requires an understanding of the knowledge and some experience with the kind of outdated practices and procedures that take place. And then using legal forms and procedures together, it becomes an issue for people who have to represent themselves, which in the legal circles is called a self-represented litigant. But your self-represented seems like an oxymoron to me, so I don't like that phrase. But a person who's representing themselves, speaking for themselves in court, first has to overcome the hurdle of understanding the forms and procedures. And actually, that's where I have been for 30 years, is working on the plain language editing of forms. But I'm usually engaged by an organization to deal with the forms they've identified as a problem. But our panelists today are going to be talking about their own initiatives they took up to resolve a problem in a specific area. So forms play a role in civil court when you've got a family matter or a dispute with your neighbor. And in tribunals, for example, like the mental health panels that we have in most Canadian provinces. And then in contracts for businesses and homes and purchases and loans between family members and such. And then, of course, in criminal courts where everything is overwhelming. So we're going to touch on all of these areas today with our panelists. And this is available.
Are your slides okay? Excuse me.
Yeah.
Are they okay? You seem to. Are you advancing slides, or are you?
Are you seeing them?
No, we're not. So you may want to stop the share and reshare. Stop the sharing your screen and then do that again. Perfect. Thank you, Daniel. Appreciate the assist.
Okay. So actually what I'm going to do is go right to our panelists. I'd like to start with Iva, if Iva is here. Is Iva here? I'm not seeing Iva. All right. Dom,
Hello.
how about telling us about your project?
A cold sweat just broke into my forehead when I looked at Iva, because I certainly did not want to be the first. Hello, everyone.
Hello.
Welcome, Dom.
I am Don Bautista, and I am the Executive Director of AC Friends Court. Before I begin, I wanted to acknowledge Cheryl, who this I guess I never asked her permission. I've always treated her to be my as my mentor, and so all my bad behavior stems from just following this lady who I adore. Secondly, I also want to acknowledge that the work that we do, and we are grateful for being able to do this, is taking place in the Musqueam, Squamish, and Tsleil-Waututh nations. And AC has a very deep uh, uh, engagement with our indigenous neighbors. So the AC Friends of Court began on a whim in the fall of 2010. And our mission then, as it is now, is to assist British Columbians complete legal forms, regardless of their needs. And when you hear this, the easy and the obvious is to think about needs in terms of money. Is the person poor enough that they actually are deserving of help? This is not something that we do. We, I think, are the only group in our province who goes out of its way to say, regardless of means. Our volunteers would never, never think about asking someone, are you poor enough so that we can help you? But it goes beyond that. Going back to what Cheryl said, there's a second piece about means. Our law, the literacy that Cheryl refers to, and the rules of court, which by design or not, is just a labyrinth of stuff that no one really knows how to make sense of on a given day. So if we practitioners struggle with it, imagine what self-litigants have to go through. And parenthetically, I'm adopting the term self-litigants because our Chief Justice in the Supreme Court of Canada, Chief Justice Wagner, used that term when I interviewed him last summer. But there's a third problem with the means test, and it showed its ugly face last year, March, middle of March, when the pandemic hit our lives. And so in trying to make sense of all this and what we're doing today, being gathered together, that is probably the third and, issue of means that we're having to grapple with. So I wanted to share three things with you. First of all, this issue of the pandemic, a lot of my friends tell me that accepting that some things are beyond our control is acceptable. And this is not something that we are prepared to accept because there is so much at stake, so that it forced AC to really dig deep to help the underprivileged, the underserved, and the unrepresented in our world, which is easier said than done. So that's number one point. Number 2 point, we view technology sort of, it's good and it's problematic. So we first take the constructive approach by saying that technology must not be a hurdle, such that all of our clients, before they actually make it into an appointment to help with their legal forms, are required to experience a 30-minute technology check, where we go through their system, find out what else they need, and help set expectations. And this has translated into much easier access to their actual appointment hour. And and I know that when I compare it with our other service provider colleagues, our attendance is very high. It's not 100%, but we're like 95, 97%, because they know what to expect. But technology is a hurdle. It is. It is a hurdle because we have clients who are victims of gender violence, who live with their abusive partners who, during at the height of the pandemic, could not leave their homes. So we would get whispered calls to say, can we talk to you on the weekend instead, because my partner has to leave the place, they have to go to work. And so we understand this. And so technology is not necessarily the answer. It may be an answer for most, but not for everyone. And when you go back to what we were saying about the underprivileged, underserved, and unrepresented, victims of gender violence are a very, very big portion of the work that we do. The third is, of course, the question of what we did. Say for 2 weeks where we had to stop operations to figure out what to do, we virtually moved from in-person to virtual mode. And we've been carrying on literally at full house every week since, April 1 of last year. But, most of our volunteers love virtual. Most of our clients love virtual because everyone's more relaxed, as you all are in this room. And so we appreciate that. But, we managed to do other things, but I want to just sort of stop there to say that while virtual has saved us from, I guess, the big problem of what was beyond our control, we managed to muddle along somehow. Thank you.
Oh, well, tell us exactly what you do and what your plans are in the next phase.
Okay, so we have British Columbia's complete legal form. So we have teams who are assembled, and we will meet with our clients at the appointed hour on a Thursday night, and we go through what they need to get done. And so even the most, I suppose the most difficult thing would probably be drafting of affidavits, because our clients have to put words into paper, and it's the role of our volunteer groups to try and put that together. And our volunteers are made up of paralegals who are experts in legal procedure, lawyers, law school students, and students in paralegal and legal administrative assistant roles. And we also recently have been encouraging foreign trained lawyers who are in different phases of how they're going to qualify to practice in Canada to assist us, because a lot of our clients are from specific cultural groups, and English is not necessarily their language of preference. And when you think about it, you've got language barriers, you've got legal literacy as another barrier. So these two together are a very dangerous cocktail. So of course, when I think about our volunteers who are now not having to travel, those who are still with us, because we experienced attrition, a great number just could not put in more time to be in front of a computer. A lot of us went back to doing a lot of writing, and we produced our own guides. For example, the guide to British Columbia civil litigation, we powered along, got it finished. The Canadian Legal Information Institute actually picked it up, and it's now available to everyone. So if you compare it with other guides anywhere, it was written specifically for self-litigants. Okay, so we advocated for their rights within, how rules are. We encourage them to think about bringing friends along when they have to appear before a judicial conference or trial, and what that means. We purposely embedded sort of a short note for them to articulate in front of a judge or a master or a registrar to say, Your Honor, I just want to ask you to provide me with some courtesies, as it's been made available by the case Pintea versus Johns, the principles of which are endorsed by the Canadian Judicial Council. So we do all these things because it's important for them to feel empowered. And so that approach is very much in the back of our minds when we write things now. And this is what we do for public legal education. So between that, holding their hands, helping them complete their forms, that's essentially what we've been up to. We've also began to produce videos, more videos that basically tell the audience how to get things done. So we produced one now, it was called How to Begin Your Family Law Case in the Provincial Court, which will lead them to certain links so that they can figure out for themselves what they need to do. And if they need to set an appointment to see the AC Friends of Court, we provide them with that URL. I hope that answers it.
Yes. And what about languages? You mentioned many people are English as a second language.
Yes, well, I'm not seeing Agustin in the room, but he, you know, so for us, of course, the more languages you speak, the more we love you. Because growing up, I am multilingual myself, and that's allowed me to understand the other person, where they're coming from. It gives us that extra lens, which is not easily found these days. So I'm finding, I don't have the stats on it, but the number of new volunteers we have speak at least one, if not two. The video that I referred to was delivered in English, of course. It's now been dubbed in Mandarin. It's been dubbed in Portuguese for the Brazilian community. I know that this month in May, Japanese will be up, Cantonese will be up, Punjabi, Hindi, and I'm missing one more. But there's like 5 languages that are being prepared now. Of course, I don't know what they're doing because I'm too old to figure out the technology part, but I just know it's happening.
Okay, thank you.
Thank you.
And thank you, Dom. And we're going to move on to Candace and Francis from Simplified Communications.
Hi, Cheryl. Do you want us to talk generally about our project, or what would you like?
Yes, tell us about this project and how you came to do it.
Okay. So, Francis, if you don't mind, I'll start us off. So, hello, everybody, and thank you to the Guild for hosting this, and to Cheryl for inviting us to participate. So, we've known Cheryl for years and years and years from the plain language world, and she's an absolute icon in plain language law. So, it's an absolute honor to be on a panel with you, Cheryl.
Thank you.
So I'm Candace Bertha, an attorney in South Africa, and I'm going to just jump straight into the problem that we had. And the problem that we had didn't start out as a problem. In fact, it appeared as if it was a solution, because in 1996, we got democracy for the first time in South Africa, and we got a constitution. And for the very first time, our constitution guaranteed the rights of people who were arrested. Because under the apartheid laws, there was frequent and legal detention without trial. And so activists, protesters, anybody opposed to the apartheid system could be arrested, detained, and you wouldn't hear from them or about them for months. So nobody knew where they were. There were absolutely no rights. And when they came out, they'd been tortured, there'd been deplorable conditions. And so when the Constitution came in with this promise of freedom and security, it was really a bright, shining light. So we were all very excited about it. And now when somebody is arrested in South Africa, they are indeed afforded 9 very special rights, which include all the Miranda rights you'll know about: the right to remain silent, the right not to incriminate yourself, the right to speak to a lawyer, the right to speak to see a doctor if you need one, to speak to a family member, and to be treated with dignity, etc. So it was a very progressive, or it is a very progressive constitution. However, the notice that is given to people when they are arrested is in a very legalistic format. So not only is the language very legalese, I mean, it speaks about things like you have the right to be treated in a manner that is consonant with human dignity. So very difficult language for people to try to penetrate and understand. And so it was this particular notice that we looked at and thought, well, if you're unable to understand what your rights are, then it's very difficult to get access to justice. And so what typically had happened in the past and seemed to be persisting in South Africa is that arrest and detention, because people weren't or aren't aware of their rights to bail, unless they've committed a Schedule 5 or 6 offense, which is the most serious of offenses, it's almost a form of summary punishment for pre-trial prisoners. And in fact, there is a pre-trial prisoner that we have in our system who has been in prison for 12 years, awaiting trial. So this is a big problem. So although we have this wonderful promise and a progressive constitution, it's a very thorny issue. So Francis, I thought maybe you'd like to say what we did, our innovation.
Sure. So I think Candice and I are guilty of idealism, but severe pragmatism. So when we looked at the problem, we saw a legalistic form that I'm not a lawyer. I'm the content person. I couldn't make head or tail of. Candice assured me it did make sense, and at its roots, it explained these 9 rights. I couldn't understand a word of it because it's all about stuff I didn't know, and we decided to simplify it. So we created a solution, and our solution, our design, if you will, was a rewritten and redesigned print version translated into all 11 languages. So we also are a multilingual country with 11 languages. Then we realized print was only a springboard because print is expensive, and a lot of people can't read, and there isn't an alignment between your home language and a language you read in. So print wasn't really going to work. We went on to audio, to voice, and that is the most incredible medium because voice is something you can listen to. It's something that's low data. It's something you don't need high literacy for. And the usage of voice and the way we underuse voice, I think, can't be emphasized. So we did our voice, translated in all the different languages, and then we created a responsive website as well. And what's interesting about the website is when we were looking at what the content to put on, we realized that we actually needed a process and not just content. So what we realized also is if somebody is being detained, they're not in the mood to listen. Or what was very important is that they're able to send their rights, send their information to somebody outside, friends or family outside the place they are detained. So our website actually allowed people to send this information about their arrest and about their rights to people out to other people. So that was really, really, I think, an interesting idea to start thinking of this, the rights not as a piece of content, but as a process of helping people get it. So that was interesting. And I think, so that's the basic solution. And I think it's worth saying if we were to take it further, we would actually probably move away even from the responsive website and move to SMS, to text messaging, or to WhatsApp, because data cost is so important. And I think that would be the kind of future medium to go in. So that's the basic solution that we came up with.
And how have you been able to distribute the information about it and get people using it?
So what we...
Well,
sorry.
You go.
So I wanted to say that where we started, Cheryl, was we tested with people who would use this content. So we went out and found some willing and some sort of dragged to the fore of participants who would be willing to answer some questions, who had been through the system, who had been arrested, who'd been detained, who'd been handed this form in a very legalistic format and language and asked to sign it. And so we went and we spoke to them. We spoke to a defense attorney. We spoke to some police officers who do the arresting, because they're also users of this document. And so that was our first step. We went to go and gather some information. And what we found out is that when somebody is arrested and they are handed this form, typically what happens is, not in every circumstance is there going to be somebody, an interpreter at the police station, a certified interpreter who speaks their language. So often the form is interpreted through non-certified interpreters who possibly add a layer of subjectivity to it because they're explaining the content as opposed to giving the information in it. And so that was one of the first things. And then the second thing that we found out in the process of it is that this is not the only document they receive when they are arrested. So when people are arrested, they have their fingerprints taken and they have to sign a document to say that these are their fingerprints. They are any things that they have on their person, they have to hand in, and an inventory is taken and they have to sign this. And they get a warning statement as well, that either they're warned to come back for the trial date, or a warning is given to them while they're still detained. And most often it's just part of the package, because then the police are able to tick it off to say, we've done all that we needed to do. So when we went and explored our solution, firstly, the print version was well received by people who could speak, who were literate, but it still took a very long time to read. The voice was absolutely overwhelmingly the route that was preferred, from the police officers who were saying, if we had this, firstly, it removes any subjectivity in the process. It removes us and this aggression or tension in the moment. And so they can listen to this recording in the language of their choice so that they understand all of their rights. And the people themselves were saying, gosh, you know, that would have been really wonderful, because I didn't know I had those rights. And at the time, you know, your brain is all over the place when you're being arrested. It's a very stressful situation. And now they're saying, well, you know, now I could actually understand what my rights were. And I wish I'd known that. I wish I'd known that I could have asked for a doctor, because, you know, there was a bit of rough and tumble when I was arrested and I was injured. And, you know, it would have been good to know that. And I didn't know that. So, and one of the men that we interviewed said he really enjoyed hearing a woman's voice speaking to him on the recording, on the audio, because he said she sounded far more compassionate to him in that moment. And they felt, and obviously this is not something we have tested, but they felt that it might have calmed the situation somewhat.
Well, let me share a couple of my experiences over 30 years. But I worked with police about the issue of literacy of clients. And one of the things we found was that everybody wanted something to be in plain language, and that it is a very tense situation. And our Supreme Court in Canada 20 years ago heard a case in which they said, it's not enough for the police to tell you what your rights are. They have to elicit enough of a response that we have evidence that you understood. Now, the problem with that is that 20 years later, that wasn't still included in the police training. And that's when I did a tour of Canada delivering training to police, but it didn't begin to cover you know, the number of people who needed to know it. But the police were most sympathetic to the idea of plain language. And in another setting where I produced audio information about the law for the public, we used women's voices because in our testing, people said the women were less intimidating than having a man telling them, what they should do. And lastly, I wanted to share something that Iva has shared with me in the video that I've posted a link to in the chat. And Iva worked with mental health patients and the forms that they are given to tell them their rights. And what she said was because they're required to sign it, it upsets the people. And these are people who've been retained, or they're being detained involuntarily, and then being told, these are your rights, and now sign here. And what they think is that they're being asked to sign away their rights, to sign a waiver of rights. So even that factor makes the situation more intimidating. So I just wanted to share those 3 examples with you. And Frances, did you want to add anything?
I think that captured it really well. I think one of the where I think that you are, what you were kind of asking, and your second point that you're raising is that it's very hard to get these kind of solutions to be adopted nationwide. And right now, this is only by voluntary. Why we speak about our solutions so often is to give it momentum and to try and get it to be wider and wider adopted, because we have the exact same experience in South Africa. It's very hard to get on a national level this kind of thing adopted. So at the moment, the people we're speaking to are more the legal aid boards and people like that, and individual teams and police stations. But at the moment, we would love to be going top down instead of bottom up, but that's the kind of reality of it at the moment.
Yeah, I understand what you're saying. It's very frustrating to do a lot of work, produce something really valuable, and then just have it sitting on the shelf for, in a way.
It is, and I suppose that's the nature of activism and the nature of kind of plugging away over time.
Okay, did the 2 of you have anything you wanted to add before we move on?
I think that the only thing to sum up is that we really, why we like this solution, and we work with a lot of legal tech startups and ambitious ideas, why we love this little solution is because it works as it does, and it's a true MVP, minimum viable product. It works as it is. It's just WhatsApp. It's just an audio file. It's just a little responsive website. It doesn't need anything else, or funding or anything else. And I think that to us, we learned in COVID, people just find a way. People find a way to do things, and that's what why we think this is innovative, is because of its simplicity.
Yes. Candace?
No, Cheryl, I'm very concerned. I'm sorry, I'm looking at your time. I suppose I shouldn't be worried about that myself. But yeah, I suppose it's really just to try to get it forward. We also felt that in the simplicity of it, putting it into plain language in and of itself is an innovation in law, because the language of the law is so exclusionary. And so merely the process of putting it into plain language, getting on board all the translators who put it into plain language in their own languages, was a really large step forward for law. Yeah.
Yes, I agree with you. And people often who are writing legal information don't realize that they are technical writers. And it is, in fact, considered technical writing, and it's not for the public. So that's our first step in innovation, is the plain language. Yes. So thank you both, and stick around. We'll have some broader discussion. Next, we're going to Jacqueline Horani, who's about building relationships between people and using contracts and other agreements to express or record those relationships. And so, Jacqueline, you go ahead. I'm just trying to find you on my list to.
Hey, I'm here.
There you are. Thank you. So go ahead.
Thank you, Cheryl. So I'm really interested, glad to be on this panel of speakers because I feel I'm learning so much from each of you, and I think we have a lot to share amongst ourselves. I was doing litigation after I graduated law school for a few years at a public interest organization. And throughout that time, I was getting more and more connected to the integrative law movement and conscious contracts, which is a trademark process, an approach of negotiation and contracting. And in my experience in litigation, where I was representing tenants in housing court, I had noticed one, sort of my growing disillusionment with the court process and system, noticing injustice and corruption within the system, and a number of failures of efficiency there. But one of the pieces we had was, and Dom, you refer to this as well, of a lot of public interest organizations, the requirement of, are you poor enough to receive our services? And so it was this threshold calculation. And the way we gathered information from our potential clients was also very hectic and chaotic, because usually we were meeting in the courtroom for the first time. There's hundreds of people there, and we're randomly approaching and talking to them for what's the next case up? Is this something that we can take on? Or there are people who are coming into our offices other ways, or just peeking their head through the door in the courthouse. And diving immediately into gathering that information before we could have a conversation always felt kind of jarring. And a number of people weren't very comfortable putting their financial information out there. So as I continued to get connected more and more and learning the conscious contracts process, I decided when I was certified that I was going to leave this work and move into transactional work where I could do more collaborative systems change approaches in law and work very creatively with my clients. Whereas in the courtroom, I was really hitting walls and not being able to create creative solutions there. So when I started my company, I decided I knew I wanted to focus on something that'd be sustainable for the future. And I wanted to create a practice of law and work experience for myself that I would want others and my clients to have, and that I believe is possible in the world, which is working in ways that bring us joy and fulfillment and that we love, and bringing in a lot more collaboration with other practitioners. So there isn't this uneasy burden and overwhelm and burnout that we tend to experience in the legal field. And through my university, I graduated from NYU University School of Law, and they were funding my student loan repayment program as part of their public interest repayment plan. So for students who dedicate 10 years to public interest, they help to make the loan payments. Since I was launching my own company, I wanted to make sure that I was continuing to address public interest work and address access to justice. So in focusing on small businesses and purpose-driven organizations that don't normally speak to an attorney, I had a number of experiences as an entrepreneur myself and with other small businesses I worked with before I ever went to law school. I knew that there was so much fear and overwhelm of speaking to an attorney, and that people did not want to spend the money that they anticipated it would cost, and that it would cost so much, $400 or $500 just to sit down in front of an attorney, where you don't even know what questions to ask or what help they might provide or what you need. And then they're going to tell you need to spend thousands of dollars to fix it. So I thought, why don't we just extend this sort of system that legal aid organizations have, but for paying clients, where instead of saying you do or don't qualify, we create a sliding scale that says everybody gets services. Either you might qualify for some pro bono services, or you're placed at a very low end or all the way up to a full rate of our fees. And this was the way that NYU really approved. I think that was their main motivation for approving my company that I was launching and the approach that I was taking. And over the years, I've had more and more attorneys come to me through the internet randomly and say, I found out you're doing a sliding scale. How do you do that? I want to do that for my firm. How did you put it into place? And so last fall, I worked with one of my interns at Quinnipiac University School of Law, who helped me to formalize the Excel template and spreadsheet that I was using to calculate these numbers, because I was continually doing it from scratch. It's based on household size and income, but it's also county specific for my work. So it wasn't just helpful to me to have state-based numbers, because New York City versus upstate New York, near Albany versus Hudson County are all very different economic realities. And so whenever I would get a new client, I would always find out what their specific county is, look up the data and calculate it out. So now we created this system. And this year, because we've had so much response, I'm going to be launching an evaluative study for people to test this out. And it's fully customizable. My grounding beliefs are, it shouldn't matter whether you are a law firm who does mostly pro bono work or does very low bono work, or if you're a law firm that charges hundreds or thousands of dollars. It doesn't matter if you are an hourly billing firm or a flat fee billing firm. This is a system that you can just easily put in. We have the US data in there. And right now we have all 50 states, and we're going to be calculating the county data for 2 or 3 major counties in each major region of the US, so we can provide some guideposts. And all you have to do is put in the person's information of household size and income, and boom, it spits out your rates based on what you put as either your low end or your maximum full rate. Now, the client experience, I just want to touch on in reference to what Candace and Francis were talking about of what that experience is like. In my intakes, I have it where I offer this as an opt-in. So I personally don't want to get more personal data than I need, right? I don't want to have that on file and have to track and record that. And so I have an intake and I say, here's a financial section. I offer my services on a sliding fee scale. If you would like to be placed on the scale, please fill out the following questions. If not, you will be offered a proposal at my full rate fees. And then the questions say, additionally, I may request additional information or your tax returns in order to verify or place you on the scale. And I put that in there because sometimes people, what usually happens is they mix up gross and net between 2 different years. I ask for the difference of what happened this year and what happened the previous year, especially something like COVID can showcase how valuable that is, right? Somebody making 100,000 last year is now making 40,000 potentially because one of the people in the household lost their job, and so they don't have the same amount of income. And so I try to take that into account. And a lot of times people put different numbers in a way or give me additional information where I can tell they're missing something. And I just usually have to email or call and say, hey, can you clarify that? But asking for the tax returns as a potential, but not requiring them, allows me to not have more personal information than I need, and also builds the trust factor there. And I haven't had any issues of people taking advantage of the system or trying to game it in any way. And I think having that disclosure protects that.
I'm curious. It's novel and everybody's making notes because they really like this idea. I'm curious about, in terms of the relational contracts, the conscious contracts, what kind of, would we be surprised to hear some of the people who've used that service?
Can you say that again, Cheryl? I'm sorry.
Have you been surprised at some of the people who wanted to enter a contract use that type of service of a conscious contract?
Yes. So not of the sliding scale, but of the conscious contracts process. Yeah. So the conscious contracts process is a more values-based and relational approach, and bringing in the plain language aspect into contracting and negotiating agreements between people. And I I think what I've been surprised in my own practice is how many partnerships I've been getting. It's like becoming the area I'm working in, even though it wasn't necessarily the intention and focus. But I think there's so much diversity that I've seen not only in my own practice, but in the community of using this in family law, in doing divorce agreements, prenuptials, working with larger organizations that want to reinvent their engagement letter with clients of whatever their contract for their service, and wanting to make that a lot more approachable and also express their true vision, their true selves. And this is a lot of what the process focuses on, is that alignment aspect. Is there alignment between the parties that are coming to this agreement? And we start with that rather than focusing on the terms. So I think I've been more just surprised by my own practice, the direction it's taking, rather than any one of the, whether it's small or larger organizations that have been participating.
Great. It's all great. I'm going to open it up now to questions or conversation. So if any of our speakers have questions of the other speakers, let's hear from you.
So I'll just throw out, Dom, I was interested in the way you were translating into multiple languages to bring this in. And I'm also getting really interested in international hiring and global salaries and ways to establish a blueprint for how we have a sort of minimum threshold, like this is non-exploitative in this country, and how to help facilitate people hiring and increasing opportunity. Because just like you said, bringing in other people who can help address the access to justice issues here, we need to increase the opportunities for those people to come in. So I don't know if you want to speak to that a bit more.
Yes, and thank you for the question. I just realized I never said this, and I should have. AC Provincial Court is 100% volunteer run. And I'm reminded by the question that was posed to me 2 years ago by the legal attaché of Mongolia, because they wanted to provide a similar service. And he asked me, how much do you pay your crew? I says, nothing. They're the ones paying me with love. And so we are run that way. But I'll tell you this. In Canada now, the biggest law school happens to be the law school called the Federation of Legal Societies of Canada. We're all foreign trained lawyers who have plans of practicing anywhere on the 10 provinces and the 3 territories. Have to get their little piece of paper that says they're competent lawyers. But of course, it's a catch-22 because, whatever training you get in school only takes you so far. So by joining us, you get your hands dirty, and it's sometimes very exasperating because it's difficult. You're not familiar with British Columbia laws. But here's the kicker. This coming, not this week, but next Thursday, we're set to welcome our second Nigerian lawyer. And we who as a volunteer, we serve from 5:15 to 8 p.m. Vancouver time. At 5 o'clock, I might get my math wrong, but I'm going to be close. At 5 o'clock in Vancouver, it's 1 a.m. in Nigeria. 1 a.m. And 2 weeks ago, I asked her again. This is not the first time I asked her. I said, I've got another project that's easier on you on your time. Why would you want to do this at 1 o'clock in the morning? She says, it's because I want to see how you guys do family law. It's of interest to me. And I think the only time she's not been able to be with us is, as you know, Nigeria is in the middle of civil war. So at 1 a.m., there are times when she has to turn off the lights so she's not seen, because there's really trouble outside her door. So I love our volunteers. They're all volunteers. Thank you.
Okay, well, our time is coming to a close, so I want to tell you that I was inspired by the Grace Swan Day to start doing the interviews with some of these people that I'm putting on YouTube. So in the link that I gave you for the interview with Dom and Iva, you can subscribe to the playlist on YouTube. And I'll be interviewing the people you've talked to and more people who are innovating in the legal arena. And I invite you to join us for that. So thank you. Thank you to Grace Swan for giving us this opportunity. And I'm available. Anybody has questions or needs some connection to somebody doing something, just email me. I'm email@cherylstevens.com. Okay, thank you all.
That's just marvelous. Thank you so much, Cheryl, and to all your guests.